Good afternoon, and thank you for joining us today. I would like to welcome you to the FortneyScott webinar entitled The Trump Administration's Focus on Higher Education. This webinar will be recorded. Today's presenters are FortneyScott attorneys Elizabeth Bradley and Nita Beecher. I will now turn the program over to Nita to start the webinar.
Hi, everyone. Thank you so much for joining. I know I can see people are still starting to join, but we'll do our initial um, presentation, the beginning of this. So let's go to the next slide. I know you all know who we are. We're FortneyScott. We're Washington, D.C. law firm. We're trying to stay on top of the craziness that seems to be going on every day. And I have Liz Bradley, my colleague, here with me. Liz, this has been crazy time for those of us in labor and employment law.
Definitely been a busy few weeks. So thanks for letting me join you today and welcome everybody.
So let's jump over to the agenda slide. So we're going to talk a lot, I should say, since we have an hour. We're going to talk about what's going on with the Department of Education and things that are going on that are very interesting. Obviously, we're going to talk about the attempt to eliminate the department, but also we're going to talk about the things that the Trump administration is focusing on for higher ed. And those are anti-Semitism, LGBTQ plus and the binary gender issue, and DE&I, which is number one on his hit parade right now. We're going to try to talk a little bit about the trends we're seeing across the agencies, and something I think, Liz, that is really important to look at is the agencies are seeming to back each other up on these issues they're dealing with in a way we haven't seen in a very long time. And then we're going to talk about expanded use of Title VI, and then just general, practical advice for everybody who's involved in this world. And, some of it, especially since we got two things that happened within the last week. Since our last webinar, actually, Liz, is we had the EEOC and Department of Justice finally issue some guidance on what is legal DE&I or illegal DE&I, whichever way you want to look at it. And also with the appointment of a new OFCCP director and what OFCCP may be doing around DE&I as well. So with that in mind, go for it, Liz.
Sure. I think the most recent sort of development was the executive order that came out on Thursday titled Improving Education Outcomes by Empowering Parents, States, and Communities. Two key provisions of this executive order is the secretary was directed to take all steps necessary to facilitate the closure of the Department of Education. Whether he has the authority to fully close it, it is something that it is for a whole nother debate and another discussion, but he is taking the steps necessary to essentially eliminate the staff and eliminate employees. And interesting kind of how this is going to roll out. We have heard there have been layoff notices issued to approximately or to thousands of employees in the Office for Civil Rights. A lot of what we're going to be talking about today is enforcement under Title VI and Title IX that is being done by the Department of Education's Office for Civil Rights. Well, if that department is being eliminated essentially through layoff notices, who's going to be facilitating those investigations? How are they going to move forward? That is something that we're still monitoring and looking at and seeing how that's going to progress. Another very key portion of this executive order was the requirement that the secretary ensure that allocations of funds are subject to rigorous compliance with federal law and administration policy, and specifically the administration policy mandating the elimination of illegal DE&I and the promotion of only two genders, and looking at how those funds are going to be allocated. A lot of this is a little bit more focused on the elimination of the Department of Education, a little bit more impacting K through 12, not so much the higher ed environment, but there's a lot of funding elements that are going to hit significantly at higher ed. So as we talk today, looking at the next slide, we're going to be looking at, as Nita previewed, anti-Semitism, the LGBTQ, the binary gender, DE&I. But what we are looking at is this enforcement roadmap that is starting to be displayed in their actions. And as we talk about each of the topics by area of attack, we're going to see the same tools being rolled out. So they're starting with these executive orders on the topic and demanding action by agencies. Then there is these agency broad statements of what their enforcement's going to be, sort of threatening where their action is going to go. And then the next step, and we're starting to see this as we're going to talk about some universities and some law firms, the targeted attack. And so the thread is going to be drawn. And one of the things that Nita and I are going to kind of talk through when we go through each one of the topics, we're going to map through how we can be expecting and seeing, oh, here's what they've done here. This is that same roadmap. And I think this is very important. We're focusing today a lot on the attacks on higher ed, but I think that's going to be the proving ground of where he's coming for all employers, especially federal contractors, where there's that use of federal funds. So this is, the lessons learned by higher ed, I think, is going to be applicable to all federal contractors.
Yeah, because you have both federal contractors and grantees,
Correct.
which most universities are both. They have both grants and they are going to leverage those. So let's talk first about the anti-Semitism. I guess it's a approach by the Trump administration. And to be honest, this is both under Title VI and Title VII. So let's go to, so we had an executive order issued. It's 14188, and it basically, so it's entitled Additional Measures to Combat Anti-Semitism. And the reason for that is in the 2019, the Trump administration issued its first executive order, anti-Semitism, which was rescinded by President Biden during his term. So they are basically reinstituting measures to combat anti-Semitism, primarily against universities coming out of the pro-Palestinian protests that were across the country after the invasion Israel made on Gaza. So what are the obligations? Again, this is similar to what Liz was talking about. You had the executive order says agencies are to identify all criminal and civil avenues to combat anti-Semitism. And they're going to be reporting on two things. One, they're going to report on any administrative complaints that were filed with the Department of Education. And they're also going to be looking at court cases. So DOE is, and the Office of Civil Rights is going to be reporting on the administrative complaints, which we'll talk about in a little bit. And in addition, the Attorney General and DOJ will be reporting on any court cases that were filed by individuals alleging discrimination based on religion, national origin, and so forth. I think the most important and most interesting item here, and we have a follow-up on that as well, is they're looking at recommendations about how higher ed can monitor and report on the activity of students and staff under the inadmissible alien provision. Now, this is the Alien and Sedition Act that went into effect in, I believe, 1792 under John Adams' administration. And it had to do with, for those of us who go back in our history, it had to do with when the British were taking Americans off of merchant ships and impressing them in the Navy before the War of 1812, what eventually led to the War of 1812. You've probably heard that the administration is using the inadmissible alien to find protesters, the leaders of the protests across these universities, and they are arresting them and looking to, if one has a green card, eliminate the green card and return these people to whichever country they were from originally. And as we also see is they want to quickly cancel student visas of all Hamas sympathizers on college campuses. Wait a minute, don't we have a First Amendment, Liz? Don't we have a First Amendment here? But anyway, never mind. What's interesting is that there's another statute that can come into play here, a criminal statute, which is basically a statute that was created to stop the Klan from intimidating people who were trying to injure, oppress, threaten, or intimidate someone in the exercise or enjoyment of any right or privilege secured by the Constitution. So they're looking to use a criminal statute as well. One other thing, and this goes back to this cancel the student visas list that I want to mention, is the fact that DOE is reaching out to the universities, and not only do they want to know what happened during all these protests where people complained about being threatened and intimidated, they want to know names, they want to know national origin, they want to know status. And one of the really difficult problems with that is potentially the universities could get caught between a rock and a hard place, because if they reveal this information about the students, they're violating the students' privacy rights. Whereas if they don't give them to the Trump administration, they could lose their funding, as we have seen. And so, that's something to take into account.
Well, and I think what's really important there, it's not even asking for the names and contact information of individuals who have found to have violated the law or
Correct.
engaged in any sort of unlawful or violent or any type of conduct. It's anyone who was a sympathizer to, Hamas sympathizer. You don't even have to have engaged in any sort of questionable conduct. If you disagree with the Trump administration's view on this, you could have your visa revoked. And I think you made that point about, don't we have a First Amendment? This is a very slippery slope. And what other views of his is he going to try to weaponize in this manner, that if you don't agree with him, you will
Correct.
be potentially, have your visa, or what other retaliatory conduct occur.
And I'm sorry, Liz, and what's really important about this is that they are not the Trump administration. The people that are in the Trump administration are moving forward and saying, we're going to do this. You're going to give us this information, and your protest that you can't, or it's legally, that legally you're not allowed to do that, will not help you with this administration. Let's go to so as Liz said last time, there's the executive order. So what kind of enforcement activity? Lots and lots and lots of enforcement activity. So coming out of the executive order, there was created by the Department of Justice a federal task force to combat anti-Semitism. And the first thing they did was to target 10 universities for their responses to these pro-Palestinian protests. And what's interesting about the visit, they were going to visit these 10 universities, and they were going to ask these universities about violations both of Title VI and VII. So violations against Jewish students, as well as violations against Jewish professors and staff. And so they're looking for those. And what's interesting is this is a little bit of a different approach. The Biden administration did step up and attempt to protect Jewish students during his administration while the protests were going on. But now they're also trying to protect, they're using the fact that Jewish professors and staff were being intimidated as well. The next step, and here we go, Liz, okay, so that was DOJ basically. Now we have Acting Chair Lucas. EEOC is stepping up and saying EEOC is going to prioritize holding these universities accountable for their hostile work environment for Jewish professors and staff. And subsequently, Acting Chair Lewis announces they're investigating Columbia University, which we'll talk about in a few minutes. Speaking of Columbia, Columbia was one of the universities. Columbia had a weird situation where the security people on campus couldn't arrest the students that were intimidating other students. They had to bring in the New York City Police Department to get things under control. But as a result of what happened at Columbia with these pro-Palestinian protests, the Trump administration has initially canceled $400 million. Even for a university like Columbia, that's real money. And they also canceled both grants and contracts, Liz, as we've talked about. One other thing I wanted to mention is DOJ is investigating the University of California system for discrimination under Title VII against professors and staff. And certain University of California systems are in the next, the Education Department, the Office of Civil Rights, which may or may not have any employees left, announced investigations of 60 universities over anti-Semitism. And one of the things that I have found is that currently there are active investigations of religious discrimination at 40 of these 60 colleges. And they were active when Trump assumed office. And most of them were fairly new. They were about 14 months old. So they are definitely they're doing what the executive order said. Anything? Yes, Liz.
Oh, yeah. I mean, I think this is that roadmap that we've talked about. So the broad executive order, they did a small, they were going to talk to 10, get more information. Reports and lists in the executive order said the Department of Education, Department of Justice had to give the White House lists of universities that were potentially problematic, right? Next thing that rolls out is the investigation of 60. And so we're going to see this same sort of the other executive orders have requirements to do reports out. What's going to be the flow back down? And I think this is the trend, and it's part of that thread that we're going to see happening throughout the various topics from anti-Semitism to LGBT to DE&I.
Well, and I think let's go to the next slide. I think it's important to point out that after Columbia lost 400 million, the Trump administration had made it very clear that other universities are, and we'll talk about some of the other universities where similar kinds of enforcement actions are going on. So Columbia caved. And I think we will see this over and over again because the universities have become very interwound with the money that comes either as from contracts with the federal government or with grants from the federal government. And to recover the funds, which it looks like they will, one, they have to ban masks on campus. And I don't know if you noticed in that first slide that we had, you saw that people were wearing masks so they couldn't be identified. That cannot happen anymore at Columbia. They then hired 36 security officers. As I said, they had security officers, but they couldn't arrest the students. What good is that? With authority to arrest the students. And I think most importantly, they're going to bring in someone to do a complete scrub of their Department of Middle Eastern, Southern, and African Studies, as well as the Center for Palestinian Studies, under the idea, I believe, that these were areas where the leaders of the protests came from. And they're also to examine the downturn in the enrollment of Jewish students in Columbia. And so here is the end of one story, and I think the beginning of a number of others.
Yeah, there's a piece here, and we're going to talk about it a little bit more in the when we talk about the binary sex enforcement issues. But if we look at this, one of the provisions of the demands that Columbia is having to allow the government in to look at the curriculum, right?
Yeah.
It's very important. The Department of Education is not authorized to control curriculum. But now, through these agreements, it's giving the government more power over education than what it existing has. And there's a few threads of that we're going to see, and I'm going to point out to you when we get to what what the administration wants the state of Maine to agree to. So being careful of what these voluntary resolutions are going to look like with the Trump administration. They're very broad, and they're going to be asking for the federal government to have a lot more authority and power over higher ed than what it normally an existing would have.
Well, Liz, that's a really good point because in the Project 2025, I believe that was one of the aspects over the universities and colleges that they wanted was to get more control over what the universities were doing with their curriculum and who was coming to the universities. Well, with that said, Liz, let's go on to the LGBTQ aspect of what's going on at universities.
Yeah. So this is being enforced under Title VI and Title IX. And so it started with, there's been two different executive orders that we're going to talk about with regard to gender ideology. The first was titled Defending Women from Gender Ideology. That made the determination that there is a U.S. policy that only recognizes two sex, and that was based on biology at conception. I think that language, I think through enforcement, it's actually going to be modified to gender assigned at birth because there are some medical issues with going with gender biology at conception. So most everything that we are seeing is rolling out to be at gender assigned at birth. The executive order also directed all agencies to enforce the laws based on this definition of sex. What they're going at here is Bostock, all right? In the Supreme Court case, the Supreme Court said Title VII protects employees against discrimination based on sexual orientation and gender identity. But if the federal agencies are being direct to enforce Title VI, Title VII, Title IX with the definition of gender assigned at birth and not moving forward with enforcing the Title VII, giving protections based on sexual orientation or gender identity. It's a direct attempt to sort of nullify Bostock through not engaging in enforcement on that definition. Government issued identification documents and forms must be changed to align to only two sexes. Passports, back, I think, I believe in 2022, you could have X on your passport. In February, the State Department stopped issuing passports that have X. As of now, those remain in effect until they expire, but we're going to have to see if anything gets changed with that. But how you're going to get renewed passports, etc. There's still going to be some questions about, and we're going to get to that. What if states allow a X or a U? How does that align to now passports not accepting that? And there's going to be a disconnect in your IDs, which could cause some travel issues. So I think everybody needs to be following these trends about how states are going to be addressing this.
It's also could be a problem when you're trying to vote. That's going to be another, where you have a disconnect between your various, whether it's a driver's license versus a passport.
Correct. Absolutely. There's a lot of ways that the difference in what your sex identification is going to be on your federal documents and the state proliferation of additional rights is going to be it's going to be fun to navigate, I guess would be the words we should look for here. Agencies are going to need to take all steps to end federal funding for gender ideology. There's going to be, and this is also, we're supposed to be getting some AG guidance. It's not out yet, but guidance on ensuring freedom to express binary nature of sex and the right to single sex spaces in federally funded entities. This is the bathroom issue. What if your workplace, your university, just a workplace that is a federal contractor, if you have single sex bathrooms or if you have gender neutral bathrooms, how are those facilities going to be running afoul of the Trump administration interpretation of this? And as none of us were surprised, this executive order rescinded 11 Department of Education guidance documents that spoke to transgender status, non-binary status. Number of issues were rescinded. So the next executive order that came out on this, and this came out on February 5th, was titled Keeping Men Out of Women's Sports. This set the policy that the U.S. was going to rescind all funding to programs that deprived women and girls of fair athletic opportunities, finding that under Title IX, it was a violation of Title IX to allow males or transgender females to participate in women's sports because it was denying women the opportunity to participate fairly in those sports. It was very clear in this executive order that the regulations that went into effect in August 1, 2024, titled Non-Discrimination, on the basis of sex in education programs or activities were vacated. A key provision of those regs that vacated was that those prior regs clarified that sex discrimination included discrimination on the basis of sex stereotypes, sex characteristics, sexual orientation, and gender identity. So those regs that just went into effect last August have been vacated by this executive order. Also wanting to protect female athletes in all female locker rooms. Also directing that there be regulations issued to specify and clarify that women's sports are reserved for women. And then prioritizing Title IX enforcement. Here we go, folks. There's going to be Title IX enforcement for schools that require females to compete with biological males and appear unclothed before males. So they're saying we're coming with enforcement. Look out, here it comes. And what happened next? So the very next day, moving to the next slide, sorry. So that last executive order came out on February 5th. The next day, the NCAA changed its policy and it was effective immediately. Under NCAA policy now, competition in women's sports is limited to student athletes assigned female at birth. Individuals who are assigned male at birth can still participate in team practices and receive the benefits such as medical care while practicing, but they cannot engage in the competition. Interestingly, participation in male sports is not limited based on sex, and individuals who are assigned female at birth can compete and practice with male teams. So I find that a little bit interesting because the drumbeat that we're getting from the Trump administration is that any consideration of sex in making any sort of decisions is discriminatory and is prohibited. Well, right here, you are treating men and women differently. Men are going to be able to be competing against individuals born female. So I find this an interesting interpretation and seeing how courts could potentially interpret it if it ever gets challenged. Interesting component of the NCAA policy that's going to thread into some of the enforcement activity by the administration is the policy expressly states that schools are subject to local, state, and federal regulation, and that the NCAA policy, and that those policies, local, state, federal policies, supersede the NCAA rule. So this is just NCAA. They're not trying to supersede any state or local that gives greater rights to transgender individuals. It was also just announced that the World Athletic Council has approved a cheek swab that they're hoping to roll out by September-ish timeframe of this year, that will be in place to determine the biological sex for competitions that are governed by the World Athletics Council. So they are moving in that direction also based on pressures by the Trump administration.
Can I just say eye roll?
Absolutely. So moving on to where we are with some of the enforcement activity. And there's been a lot of, we've all heard about UPenn, and they just approximately 5-6 days ago, it was announced that 175 million of funding was being suspended by the administration. This stems from 2022, a transgender female competed for UPenn, and the former UPenn swimmers, female swimmers, have filed suit seeking to nullify the transgender females' records. UPenn has been very clear in stating that they have always followed NCAA rules, both then and now. So that one is still pending, and we'll see where that's what's gonna happen with the UPenn situation. Maine is another interesting situation. So both the University of Maine and the Maine Department of Education are being subject to enforcement. This rolls out of back in May in month or so ago. Days they blur. I can't keep them straight anymore. But the Maine Human Rights Act back in 2021 was amended to allow gender identity as a protected class. And in a heated exchange with Trump, the governor of Maine, Janet Mills, told Trump that Maine is going to comply with the law and they'll see him in court. And then this is the result of that is both the University of Maine and the Maine Department of Education were subject to investigations by their funding, to the funding sources. So the USDA did an investigation of the University of Maine. They found it to be in compliance with Title IX. So no violation has been found against the University of Maine. According to the University of Maine, they do not permit students who are assigned male at birth to compete in women's sports, and that no such student athletes are part of the program within the university. So the University of Maine investigation appears to be closed as of now. The more interesting one is the Maine Department of Education. And so this is looking at the K through 12 programs. This is mostly focused on their high school programs. And HHS did an investigation and they have found violations. Maine is challenging DOE's jurisdiction under Title IX, saying that they are not receiving the funds that give the authority to have this finding. But the really most interesting part of the Maine and the piece I think that is for all of us to be thinking about if your enforcement activities against your organization, there's some provisions of the proposed resolution agreement that we expect to see, of course, comply with the male-female definition in the Trump executive order. They want Maine to pull back any awards given to individuals who are male at birth and reissue those to any females anyone who's female at birth who may have missed out on the placement, the medal, the award. What's interesting is they also want formal apologies issued to those students, annual certifications of compliance, sort of expected. But the real kicker here in the Maine Department of Education is they want Maine to agree that federal law supersedes state law. So what Trump is going after is the Maine Human Rights Act that gives gender identity as a protected class. So through this resolution of the Maine Department of Education, they're trying to undo the prior amendment to the Maine Human Rights Act. And I think that's a big deal as we're looking at states' rights, where states can give individuals greater protections than provided under federal law. And I think this is something we all need to be looking at very closely and monitoring closely to see how this is going to roll out and impact all other states as well.
Liz, this is very much right in line with Project 2025, which wants to overturn Bostock and all the stuff that had flowed out of Bostock.
Yeah. And I think, and we saw this happening when talking about the anti-Semitism, where he's trying to get control over state laws through some of these actions. So
Yeah.
it's the amassing more control and power.
Well, I think, Liz, now is the time to talk about the big elephant in the room these days, which is what is illegal DE&I? And we're going to be talking about enforcement, not under Title VI, Title VII, and Title IX of the Civil Rights Act. So let's do a recap. So where are we with our favorite executive order, 14173? We'll talk about that a little bit more, but I just wanted to give everybody a quick update that the executive order, the portion involving the certification, was initially given a national injunction. And it was then clarified that it applied to all agencies because I know many federal contractors and grantees were receiving emails from their federal agencies saying, so you're in compliance with 14173, right? To which we said, well, don't do anything until you talk to your lawyers. But that has now been lifted. On March 14th, the Fourth Circuit had stayed the injunction, but they are going to have an expedited hearing. So I'm hopeful that we will have some finalization on the certification process sooner rather than later. And the Fourth Circuit is, it is a conservative circuit, but I think it's also, very institutional. So we'll see where this rolls out.
What's
Yes, ma'am.
important about, oh, sorry, just
No,
chiming
go ahead.
on that one real quick. We are hearing that there are agencies that are seeking to amend contracts, putting the certifications, it's the language. We're seeing that has come out. So everybody be on the lookout for those. Just whoever is in charge of your procurement, make sure they're checking their emails.
Exactly. And this is both grantees and federal contractors.
Yes.
Okay, so let's just remind everybody where this DE&I, anti-DE&I comes out of in this particular executive order. So Section 3, which we were just talking about, requires federal contracts to include new certification material under the False Claims Act, and we have a whole webinar on that if you want to know more about the False Claims Act, that the contractor does not operate any programs promoting DE&I that violate any applicable federal anti-discrimination law. Under the original injunction, the judge was very uncomfortable, felt that what is DE&I was void for vagueness. So we are going to talk about the government trying to give more clarity around what is DE&I that's illegal. And then Section 4, and we're going to talk about this more as well, is really an attempt to squash DE&I outside of federal contractors. So it's already rolling out requiring agencies and the Attorney General to submit a report in the middle of May to identify the most egregious and discriminatory DE&I practitioners in various industries and identify up to 9 potential public corporations or higher ed institutions for litigation, including criminal litigation, according to the Attorney General. And that would be under that Klan statute. And what think you, Liz?
Oh, yeah. Well, I mean, this is, as we talked about before, this is the executive order telling them to give these lists to the government. What happened the last time these lists were given to the government? We've got 60 universities that are under investigation, right? This is going to be the next round. And that's not a total of 9. That's 9 by each agency of the government.
Over
So
400 agencies, right?
correct. Over 400 agencies, each one has to identify 9. So there's a lot of potential for universities and other contractors to be on a list that's going to get additional scrutiny.
So Liz, the Attorney General has issued a memo to provide a little guidance on illegal DE&I as well, involving specifically higher ed.
So yeah, so this is that next, we got the executive order, and then the executive order issued directive to take action. And the first thing we got on February 5th was a memo from the Attorney General citing the Students for Fair Admissions, and the statement, eliminating racial discrimination means eliminating it for all. It directed educational agencies, colleges, universities who receive funding. And again, there's this funding thread that is going to be broader than just applicable to higher ed, and that you cannot treat some students worse than others because of race. It states the AG is saying that the DOJ will work with the Department of Education to issue directives, and that the Civil Rights Division will pursue actions regarding measures. So this is setting forth the enforcement landscape. It also threatened that higher education institutions would be subject to both civil and criminal investigations. And some of the language that was used in this letter included vigorously defend and other actions saying, get in line, you need to be reviewing your policies or we're going to be coming into enforcement action. And then following, oh, sorry, go ahead.
Oh, I was just going to say, and this is, again, ratcheting up the pressure that comes out of the executive order and rolling out saying, we're coming for you.
Yep. And then following this, as directed, the next thing that occurred, and I think we can move to the next slide. There we go. Two different actions out of the Department of Education. The first was a Dear Colleague letter, which again cited to the Students for Fair Admissions case, again saying to achieve a desired racial balance to increase racial diversity is unlawful, and setting forth essentially mirroring that you cannot engage in any activity that has any preferential consideration based on race. And then along with that, the Department of Education issued FAQs. And I think the FAQs have a lot of pieces, and they were issued on March 1st. Those FAQs have a lot of good information. It's starting to get some clarity on what is illegal DE&I. And I'm going to say some of the stuff that's in those FAQs and be listening, because Nita's going to mirror me when we start moving on a little bit more with some of the stuff that other agencies have put out. So this is where we're kind of starting to see those trend lines and the threads that are linking the different agencies. First of all, I think we got some good news. DE&I, simply having a DE&I program, these FAQs say, is not unlawful.
Yeah.
Right?
And are you still, you're on the FAQs for the universities?
Department of Education.
Yeah.
Nope, we're on this slide.
Yep.
Yep.
And so they also said that DE&I in and of itself is not illegal.
Correct.
There's a trend here.
Correct. So, the FAQs from the Department of Education say it's not dependent on terminology, or it is dependent on terminology. It's not just DE&I, but it's the substance of those programs. And the nice thing is, if they're focused on the interests of particular cultures, heritages, areas of the world, cultural and historic celebrations, that is not unlawful. You can continue those. You just cannot restrict anybody from attending those, and they cannot be exclusive events. It also said that discussing DE&I is not prohibited, but you've got to look at what it could get to the point of a hostile work environment. So again, you have to be looking at the substance of those DE&I messages, what the curriculum is, and how it could be deemed to be a hostile work environment for certain individuals. Another piece of the FAQs that I think is very telling about where the administration is going to go next in some of their enforcement is there was a very short, sweet, to the point direct question about how does Title VI impact procurement of goods? So if you are receiving federal funds, you cannot discriminate based on race, color, or national origin in choosing your subcontractors. Boom. Supplier diversity is right there. And then finally, this is a piece that is is the voluntary resolution program. And it talks about it's going to offer you these written resolution agreements. And we see that in Maine, what they're doing in Maine. If you're not willing to enter into their version of these written resolution agreements, which I think are going to be very broad and very burdensome, they are going to be going straight into enforcement. So there's sort of the pieces of the FAQs that I think are most telling and important.
Liz, that's really important, because let's go to the next slide. We're now starting to see a trend line of what agencies are all starting to tell us the same thing about, what they consider to be illegal DE&I. What's interesting then, on Wednesday, which was the 19th of March, The EEOC and DOJ issued guidance on what was illegal DE&I. Again, I'm anticipating, I suspect, the Fourth Circuit argument that'll be coming up. What's fascinating to me, though, is the guidance is all from the perspective of the employee. There was a sense by looking at this that this is an attempt to, shall we say, drum up business for EEOC and DOJ around individuals feeling that employers are still engaged in what they consider to be illegal DE&I. But I think this is the most important thing that we walked away from, Liz, and I'll be here interested to see what you think, is that any initiative, policy, program, practice is going to be considered unlawful if the employer makes an employment decision, very broad. What is an employment decision? It's not just hiring, promotion, firing. It's a whole bunch of other stuff. But if that decision is made in whole or in part based on race or sex or other protected activity, it's illegal under Title VII. And I think you see something very similar in those FAQs that were issued as well, I believe.
This language this is a thread. This type of statement, very almost verbatim, is what we are seeing coming out of DOE, DOJ, EEOC. We are getting that consistency now. Again, it's going to be for courts to do some sort of interpretation here about what actions get to that line. But I think that if at any point in time you chose race or sex was at all considered in making decisions, employment or with regard to students, I think that is going to be attacked by this administration.
Yeah, and so let's talk a little bit about let's get in a little more detail on that. So not only did EEOC issue what looks like a poster, which is entitled "What to Do If You Experience Discrimination Related to DE&I at Work," they also issued a series of FAQs, not what they called them, but FAQs is the easiest thing, and that's entitled "What You Should Know About DE&I Related Discrimination at Work." So I think the guidance, and again, this is guidance, it was issued as technical guidance, which perhaps the acting chair didn't really have the authority to issue, but we need the guidance, so I'm not going to complain. One, back to Liz's point about the FAQs that she was discussing, DE&I programs are not necessarily illegal. Talking about DE&I is not prohibited. However, because of the Muldrow decision, which came down this past year, the ability of someone to file a charge and be successful under Title VII is much broader than hiring, firing, and so forth. It is now it's developmental programs. It's so pointed at DE&I, it's unbelievable. It's training, it's development, it's anything, lateral moves, it's anything that someone believes gave them some injury or some harm affecting terms and conditions of employment. That's a very, very big term. And employers and universities need to really look at it. The other thing that's really tricky, I think, and they're talking about ERGs here, is you can't segregate applicants and employees based on protected characteristics. So you can have ERGs, but you have to have them open to everybody. So if you have an African American or a female ERG, one, if you have development programs specifically for them, that's a problem. You need to open them to everybody. Better to maybe even move them out of under the ERGs into sort of your overall developmental groups. And you have to allow, so if you have a women's, you have to allow men, if they wish, to attend and participate. And I think, Liz, this is really important. If someone comes to you and complains about, I have a perfect example, client had a mentoring program for women and minorities. A white male came to them and said that they felt that was unfair. The company said, well, we're happy to give you a mentor. And he says, I don't want a mentor. I just think it's unfair. So potentially that could be protected activity, which means you cannot discipline someone, you can't retaliate against them, and you need to do something about it right away. I think that's very important, Liz.
I I do too, and I think another example of where this is going to come up, I think probably pretty frequently, is individuals complaining about mandatory training. 'Cause who likes to go to mandatory training anyways, right? But so somebody's going to can raise their hand and say, I think that this training violates the laws about DE and I. Is it too progressive? Whatever they're, and
Right.
remember, engaging in protective activity, filing a complaint about it, they don't out to have to be successful in their complaint, right?
Correct.
They have raised their concern. So you now have an employee who has raised a concern about having to attend a workplace training. And can you, once you've reviewed the training and you don't think it's violative of Title VII or any, but can you require the employee to now take that training? Or is that essentially nullified the mandatory nature of some of your training? And I think there's going to be a lot that's going to roll out related to workforce training, what's in those trainings. Everybody really should be looking at what training is mandatory. I think the mandatory elements of your training need to be very narrow to
Yep.
permissible grounds to the extent you want to offer any sort of unconscious bias or any of the other broader scopes of training. Those really need to be converted to being voluntary and optional and not dependent on any sort of workplace advancement to having been kept that, because I think workplace training is going to be one of the first areas that people who are
Yes.
opposed to DE and I will start complaining about.
Absolutely. So just to close this out, we've got a couple more slides, but because we're going to run out of time here, and I don't want to do that. It's number 7 FAQ is the answer. When is a DE&I initiative, policy, program, or practice unlawful? Read that completely and carefully, because that gives you the answers you need to know as you review underprivilege, I hope, your DE&I programs. Well, Liz,
Well,
it
and I
was,
think let me just ping on that and then we'll move
yeah,
forward. But we need to read the DOJ guidance. What is illegal DE&I along with the
correct.
DOE FAQs, because they are aligned in some places and other places they one of them gives a little bit more nudge. So they are very closely aligned, but we are now having a source of some sort of guidance. Sorry, Nita.
No, I just, let's go. Liz, can you talk a little bit about the EEOC letters to the 20 law firms?
Yes. So, on March 17th, the acting chair Lucas sent out letters to 20 law firms seeking information on their DE and I practices. So, I think we could do an entire session on these letters alone. So, mindful of the time. Um, a couple interesting things. The fact that it was publicly done, we're not sure these are technically investigations. What is the authority under this? That's an entire scope of questions that we can, allow others to opine on. But for the purposes of today, they are looking for very detailed information from law firms, the EOC is, for applicants and employees and some of their clients, and they're wanting information about any and these are programs related to sex and gender, but fellowships, internships, scholarships that are focused on that, hiring and promotions, any programs related to the hiring and promotions of individuals, and those development opportunities. That goes to where Nita, is your training for leadership only hosted by the female ERG, and are others able to get into that, or are you only given women leadership development programs? These are things we need to be looking at, or minority-based development programs. Staffing decisions. Here's an interesting one. Have the law firms made decisions about the diversity of the legal team or other professionals assigned to their work based on clients' demands for diversity on their projects? So they're starting to thread that through and asking if clients have demanded diversity in the team working on their matters. Who are those teams? What was asked? What was produced? So this is a
And
pretty.
who are the clients?
And who are
And
the
who were the
clients?
clients who asked? Which is a whole nother long discussion we're not going to have today.
Right. And so I think, everybody out there who, and the list of the 20 law firms is out there. You can grab it. If you are represented by one of those, you need to be having some conversations with legal about how they're responding. Of course, we're not surprised to see the request. Do they have diversity goals? How are they monitored, tracked? Are they incentivized? We knew those types of questions would be asked, from a diversity standpoint. Diverse slates. The Rudy Rule, it's under attack. Do you mandate diverse slates? The EEOC is looking at that. And then, as looked at earlier, the ERG participation, and specifically, is there any incentive to employees, or is there leadership development, or participation in ERGs? Does that prepare them to be promoted anyway? So these are some of the broad scopes of data that's being looked at. Again, a lot of it was kind of expected if you're going to be investigating DE&I programs, but I think the staffing decision component and looking at, are you doing diverse teams based on client demands, is something that we all need to be mindful of and aware that the EEOC is trying to get.
So Liz, I want to do one quick slide and then we've got to close out here. We're going to run out of
Absolutely.
time. So yesterday, as we're getting ready for this webinar, we hear OFCCP is back. It's back. They have a
Is
new
it?
director. They're back. They went away. They're back. And some very interesting, there is an internal email that people got copies of, and the Wall Street Journal has a big article about. It appears OFCCP is going to review priorly, let me try that again, prior submitted affirmative action information from closed audits to determine whether they need to reinvestigate you. So just be prepared. They're also going to be doing this whole, measures to deter DE&I. They are going to be looking at what they should be doing on 503 and VEVRA, and they're not eliminating the entire department. They said they're going to right size it. So we'll see. But the most important thing is they're going to review prior submissions, and they may be coming back. So Liz, we're almost out of time, but I'll let you.
One piece on that, and so I don't, for those of you out there, and again, muddy crystal ball about what this means, right? But if you recall, there were OFCCP actively scheduled audits at the towards the end of the Biden administration, and a number of audits, the 11246, they sent notices saying the 11246 provisions were closed. They didn't complete the investigations, they just closed them based on the revocation of 11246, and the 503 and VEVRA sections were held in abeyance. So we don't know if this statement is focused on that group of audits, meaning the ones that were closed without being completed for 11246 and the 503 and VEVRA, or are they actually going to go back and do ones where the audit had been completed and a notice of compliance or a conciliation agreement was previously reached? Which side of that, or what is the scope of this reopening and re-reviewing? We don't have any additional clarity on yet, but we're going to be keeping our eye on that. But
Yeah.
if you get a notification, if any of you had audits, you should be reaching out to your counsel immediately if you hear from the agency.
So let's skip over to our final thoughts, Liz, and I'm going to let you kick it off. One more. There we go, because we're almost out of time here.
I feel like we're a little bit of we're beating this drum, and I can't say it enough. I can't. Review all of your DE&I practices, right? Just because it says DE&I doesn't mean it's unlawful. So you can keep some of it, but you need to understand what those actual programs are, and you need to be assessing those.
Well, and secondarily, you really need to review and strengthen your non-discrimination, anti-discrimination investigations, and also your hostile work environment investigations. Make sure that your EEO office knows how to handle people who come in and complain about DE&I.
Right. Or, I mean, this is where the schools are got targeted because they didn't respond strongly enough to some of the anti-Semitism. So this is really important. Evaluate your risk. Obviously, you all need to know where you want to be and sort of, what hill are you going to stand on? And that's going to help determine your risk tolerance throughout all these decisions that you are all about to be able to make.
Well, and remember, you're going to be certifying that you are in compliance with all the federal anti-discrimination laws. You need to make sure you are. What about your charges? What about where are you? What kind of litigation and so forth? You need to know that. And Liz, finally?
Well, I think that's, and at that point, I see Sarah is back on, but we're wrapping up. But thank you all for joining us today.
And one last thought, Sarah, if you jump to the last slide, we have a resource page. We're updating it. Please feel free to jump on. And Sarah, you're up.
We would like to thank you for joining us today. If you have any further questions, please email us at info@FortneyScott.com. A recording of this webinar and a copy of the PowerPoint will be available to all those who attended. This will be sent as soon as the webinar recording is available, and stay tuned for our next podcast and webinar.